Nice to see everyone here. I'm Robin Feldman. There are a lot of familiar faces, so I should start by saying that I had hip surgery about a week ago, which is why I'm hobbling around here, but it's only temporary. And that also means that anything I say, good or bad, can be attributed to hangover anesthesia, so I'm free from anything I say here. It's nice to see you all. I'm talking about a paper, Regulatory Property, the New IP. So for almost 30 years, a new form of intellectual property has grown up quietly beneath the surfaces. It spans more than a dozen programs, and it confers hundreds of billions of dollars in benefits, and that's not an exaggerated number. Its impact on the U.S. healthcare system is enormous. In 2014 alone, more than 40% of all new drugs approved by the FDA came through just one of these dozen programs, with the companies collecting regulatory rights along the way. Now, some forms of this regulatory property are quasi-patent, some are quasi-trade secret, and others look more like personal property that can be traded or sold. Creation of this system follows absolutely no theoretical design. It's sprawling, it's incremental, and it's grown by accretion, as various groups have argued that they too should have a benefit. Now, treating regulatory property in its rightful place among the pantheon of intellectual property rights allows appropriate analysis of the intersection among these powerful forces. And I want to say that it isn't just a matter of labeling these phenomena as forms of intellectual property. I know labeling is something that law professors love to do, but it's more that without a coherent construct, there's no way to intellectually shape its development or to test its success. Thus, the paper also sets out a general theoretical framework for thinking critically and cohesively about this new form of property that has emerged. Now, most of these regulatory rights look like revised versions of other intellectual property rights, and they often have the feel of having been created by market actors who, after living with certain types of intellectual property and regulatory systems, wanted to just adjust them to better fit their needs. Let's see this. All right. So these regulatory rights fall into three baskets. The first basket is marketing rights. That is, no other company can receive permission to market the drug. Marketing rights can be analogized to patent rights, although they are somewhat stronger than patents. For example, patent rights are not self-executing, so patent holders have to file suit if they want to enforce their rights. In contrast, the FDA enforces these marketing rights by refusing to grant approval to any other company. The second basket is data rights, and these are quasi-trade secret rights. With these, other companies may not use one's safety and efficacy data, but they may conduct their own trials. Now, data rights are related to a requirement that drug companies make their safety and efficacy data available to generic companies, but the information can't be used for a period of time. Thus, and this is really important, I think most people don't understand, even if a brand name company's patent is invalidated, the brand name company still gets a form of protection through data rights for a period of time. The third basket is made up of tradable rights. A company can use that right on another of its drugs or transfer that right to another company. And these are more analogous to personal property that can be traded on the open market. Now, it's challenging, if not downright impossible, to find a clear and comprehensive explanation in any location of all of these forms of regulatory IP. And what's even more challenging, however, is to find any hint of the historic context in which they emerged, and that history is significant. Though repeatedly over 30 years, legislators have created regulatory IP in the same Congress in which they passed major laws that the industry resisted. So first, regulatory IP was born with the passage of the HatchWaxman Act, which created an expedited pathway for approval of generic drugs. As you can imagine, drug companies were not anxious to help generics climb the on-ramp of competition, so HatchWaxman offered various balms to soothe the pain of generic competition. These include a 4 or 5 year data right for new chemical entities, a 3-year data right for new studies on existing drugs. Now, rights like these can be added together, so you might receive something like a data right for a new chemical entity then later engage in certain types of new studies and qualify for an additional 3 years of data protection. And finally, to the center stage, orphan drugs, which I'm assuming most people are familiar with, the Orphan Drug Act. Of all the brilliant strategic choices ever made, naming this regulatory scheme the Orphan Drug Act surely ranks among the most inspired. Because if you are in Congress, who could oppose medical treatment for orphans? Particularly not when congressional testimony includes Hollywood stars reenacting heart-wrenching dramatizations. So, of course, the program has nothing to do with actual orphans. In theory, it provides incentives for drugs to treat diseases that affect only small numbers of patients. The economic theory was, and yes, I am a fellow traveler of The Economist, but I try to keep my nose out of trouble. But the economic theory was when the consumer base is limited, the potential returns are too low, so greater incentives are needed to encourage investment in drug research. That's where this started. Under the program, orphan drugs get 7 years of marketing exclusivity, meaning no one else gets approved. And there are some other benefits. Orphan drug does not have to be a new drug. Companies can get orphan drug status for a new indication of an old drug. Now, wonderful drugs have been approved through the Orphan Drug Portal, but some would say the program has been too successful. In fact, orphan drugs seem to be dominating the modern medical system. So 44% of the new drugs approved by the FDA in 2014 had an orphan indication. 44% of all of the new drugs. And of the top 10 best-selling drugs, 7 are orphan drugs. And finally, the price of orphan drugs is shockingly high. The median cost per patient of 1 year for an orphan drug is $99,000, with the cost for ordinary drugs roughly $5,000. Although I think that's changing with the eye-popping increases in drug prices across the board. So that just means the delta is getting smaller. Everybody's going up to the eye-popping range, but it's still all expensive. To some extent, high prices for orphan drugs are understandable. If a company must recoup its investment over a small group of customers, the cost per customer is bound to be high. The problem is that in many cases, those high prices seem to be spread across much larger populations than the Act anticipates. I call this spillover pricing. So one of a number of spillover techniques involves off-label use. That's when doctors prescribe a medicine to treat something not one of the indications approved by the FDA. So a company seeks orphan approval for a small group of patients from the FDA and then promotes the drug off-label to a large group of others for other uses. So, for example, the Lidoderm patch was approved as an orphan drug for a painful complication of shingles that affects nerve fibers. The company, however, earned more than 80% of its revenue from other uses like treating sports injuries. Now, another technique is called salami slicing. The company divides the treatment population into small slices and obtains different orphan designations for each slice. This once was described to me by a practitioner in terms of, I'm going to define my population as males between the ages of 20 and 30 who have hit their head on the car getting out within the last 6 months. All right, so the saga of the Orphan Drug Act always reminds me of the Gilbert and Sullivan operetta Pirates of Penzance, where the pirates lament that everyone says he's an orphan. Okay. So the next group of regulatory IP benefits were granted during the Congress that passed the America Invents Act and the Biosimilars Act. But once again, when Congress passed legislation that the drug industry bitterly opposed, the same Congress passed several pieces of legislation creating forms of regulatory IP. This time we see protections for drugs for infectious diseases, biologics, and for pediatric drug trials. So this is the full chart of all of the types of regulatory IP together. The last 3 items on the chart are tradable vouchers. The company gets either marketing rights, data rights, or the right to an expedited review of the FDA. Company can use that on another drug or sell it to another company. These are incredibly valuable rights. Studies estimate that vouchers for expedited FDA approval are worth hundreds of millions of dollars, and in fact, one was recently purchased for $350 million. So in short, society has created this system of regulatory IP by accretion generally in conjunction with legislation that was difficult for the pharmaceutical industry to swallow. And the result is a tangled beast. The problem is not with the value of each. Drugs for antibiotic-resistant bacteria, for cancer treatment, and abuse-deterrent opioids are of great societal value. The problem arises when there's a mismatch between the value created and the cost and effectiveness of the programs. And this is particularly a problem when regulatory property rights interact with other IP systems. I go through a number of the issues that come up in the piece. I want to turn very briefly in the last couple of minutes to a theoretical framework for the regulatory IP that has emerged. And I say in the opening of the paper that one could make a case that this stuff shouldn't exist. You shouldn't have regulatory IP. But I think that's rarely practical when you have something that exists in such an extensive fashion. It's not going to disappear. So the question is, how can we rationalize it, make it the most effective system that's possible? So at a high level of generality, the goal with the creation of regulatory property can be described as promoting the development of safe and effective medical treatment. That's the way I would think of it. That goal is both broader and narrower than patents and trade secrets. So specifically, when your goal is safety and efficacy, that carries the need for certain types of value judgments that are unlike anything we see in other forms of IP. The patent system, for example, does not care how safe a drug is, only that its workings are different from what has come before and that there's some utility, that's it. And in fact, the pursuit of safety and efficacy values things that are the antithesis of newness. The safety regime relies on continued evaluation and patient experiences of adverse effects. That's not something that our patent system has any interest in or is very good at. Now, not all aspects of other goals of regulatory property are in conflicts with other types of IP. So in particular, promoting the development of safe and effective treatment includes, of course, the notion of promoting development. It's where all of these regimes rub shoulders that there's a risk for each one's goals and limitations to conflict. So let me set out one example of this conflict. This is in one of the congressional reports. It makes little sense if, in the interest of promoting innovation, society denies patent rights to an invention that is too ordinary and then grants almost the same type of protection in the context of drug testing. So different goals demand different types of incentive structures, not simply one tacked onto another. So regulatory IP should not be a matter of granting an extra goodie here or there. Shouldn't be a way to tinker at the margins with something that dissatisfies a particular interest group. It makes most sense when it's aimed at incentivizing activity for which other intellectual property regimes are fundamentally ill-suited. As a general matter, the goal should be as little overlap as possible. And for the IP faces I see in the room, I just point out that where you see overlap between intellectual property regimes, these tend to be a signal of difficulties, not a joyful combination or an intersection of ideals. I think of them as rough road ahead signs. Regulatory IP should also be evaluated by whether the programs are stimulating results we desire, and most importantly, whether there is some metric available. If we're going to propose something, how do we plan to test it against what it is that we say we're doing? The paper sketches out issues related to each of these. So, in short, the appeal of understanding regulatory IP as a unified system lies beyond the sublime beauty of logical consistencies in theoretical constructs, although that's nice. From an instrumental perspective, understanding the regulatory IP system as an integrated system is essential for thinking critically and cohesively about this new system that has spread its tendrils throughout the healthcare system. Thank you.
Perfect timing. You can choose.
Okay, sure. Yes.
Hi, Robin. So a couple of things. First, if one wants to understand the background of how these regulatory properties develop, you need to actually go beyond the FDA. You need to go to FIFRA, to the Federal Insecticide, Fungicide, Rodenticide Act.
Yes.
Where you can see how exactly these basically ingenious mechanisms were thought out in a fight that spanned basically since the 1950s through the end of the 1970s. And so the first of these regimes was really instituted in FIFRA in 1977, one of the amendments to FIFRA. There are two more of these regimes that also were granted, as candy for the industry. One is in medical devices,
Yes.
and the other is in veterinary drug products.
Hmm.
And the veterinary drug products regime is a mirror image. Actually, not a mirror image, a replica of the HatchWaxman Act regime. Now, I share your concern about where these regimes overlap with patent regimes. And I think that the best example for that is actually in the context of biologics, where based on a calculation that I did in an article from 2012, the exclusivity, the marketing exclusivity that you get under the Act is exactly at 12 years. The industry said they said that it takes them 11.9 years
Right.
to recoup the investment, but really that's pretty much the same as what they would get in their biological products under patent law, or at least that's the average that I got based on calculating 79 products. So we're yet to see how that plays out, but I think that we're going to see that it plays out pretty much the same way we saw in HatchWaxman, where they use some aspects of each of the regimes to pester new entrants.
So I think that's probably right.
Say who it was and sort of summarize the question. Sorry.
Sorry, I
That's
don't
the
know who it
Lawrence.
was. Thank you. Yaniv Helled asked the question. There was a reference to the data rights system that came in related to pesticides in the 1970s as a precursor to this. I'll talk about that in a minute. Examples of other regimes in the veterinary medicine space. I would love it, by the way, Yaniv, if you would send me those two references. I focused on humans, but I would love to see what else is there. And then as well a view that this is tied to the way in which the drug industry characterizes itself and the benefits it would like to see have a remarkable way of popping up in different types of congressional proposals. I think that's how I would summarize it. The history that you referenced going back in the 70s is really interesting because before that push, there was no notion that data, safety and efficacy data, was a trade secret. That was considered that if you were going to ask for approval from the government, that should be open information. So the notion that that information is a trade secret was created by the industry itself within that particular context, and then it migrated into what we see now here. But it's interesting to stretch your mind and think about it and say one doesn't have to think about it that way. Other questions?
One very quick question.
Yes, one quick question, yes.
Yeah, go ahead.
A unifying theme here in the advocacy for these protections is a policy rationale, perhaps rather weak, that focuses on adjusting regulatory IP to nurture clinical value or to take account of clinical value. And then your potent story here is one of how, with the help of really smart lawyers trained by the people in this room, this system gets ruthlessly exploited and becomes a monstrosity. Has there been, a thing that's missing from this is a conversation about how one might in real time adjust these various forms of IP protection to take account of clinical value as it emerges once products are actually on the market. What are your thoughts about why that conversation is missing? I mean, that would require a lot of delegation to agencies, obviously, but do you have any thoughts about why that conversation is missing?
And you only have about 10 seconds for your thoughts.
10 seconds. In theory, regulatory rights could be designed to take account of clinical value and changing information they have. They're shorter, they're more nimble, and they're operating out of the FDA. That's where I think they're most useful and where we should begin to look at it. Why are we not having the conversation? Because I don't believe the conversation is driven by a societal interest. I believe if you look at the histories and the definitions, the conversation, the rights are driven by a particular company or interest that wants a benefit and gets it through Congress, and we live through it.
Thanks very much.
Thank you.
and look for my next gig, for me, this was the field I wanted to be in. And I know that this was not an obvious field to go into, a decade ago, 20 years ago, but for me, it was the field to be in, the most awesome field. And I know many of you in this room paved the way for me. So just being here, it's really, really great. In that spirit, though, I'm not presenting a paper that I have written. I'm presenting a prototyper, and I'm hoping you can help me with that. And I'll explain a little bit what the prototyper might look like and where it comes from. So in my first year teaching IP and FDA law, I wrote, or almost wrote a paper called The IP of Ebola and Zika that had to do with different ways in which IP impacts the development of vaccines and drugs for outbreak diseases. So I was analyzing the development of the Ebola and Zika vaccines from an incentives perspective, so the pre-outbreak period, and then when the time came to license pre-existing IP and emerging IP, what happened, what went well, and what went wrong, and that was my main piece for this year. A companion piece had to do with the priority review voucher program. Thank you very much for describing it for me, to which Ebola and Zika were added. And at this point, my interest in the role of the FDA in situations like an Ebola or a Zika outbreak started growing. And this is the basis for the paper, one of the papers that I'm hoping to work on next year. So I've been trying to figure out how the FDA works. And when you start reading about FDA, there's the traditional gatekeeping function. And then the function of gathering information, particular types of health information. As Zika and Ebola illustrate, also FDA contributes to emergency preparedness. And something that Robin has also touched upon, FDA also provides certain types of incentives or carrots for certain types of innovation. So I was trying to see for this new paper, or I've been trying to think about ways in which FDA has done all this during the response to Ebola and Zika. And this is a list of what I've come up with so far. So the most obvious thing, and the gatekeeping function, is the Ebola vaccines and the Zika vaccines approval pathway, which is unlikely to happen under the traditional pathway, even under the accelerated approval pathway or animal rule. What we have seen in the context of the two crises is the emergency use authorization, which the FDA can resort to during public health emergencies, and I'll come back to this in just a minute. These EUAs, so they can be used for serious or life-threatening conditions when there's no available alternative, and the FDA has to engage in an analysis, benefit versus risks. And for Ebola, there were 11 EUAs issued since August 2014, and for Zika, 15. So this is FDA wearing two hats, at least as I can tell. One is gatekeeping, but the other one is also the triangle, so responding to emergencies. Next, we have the expanded use program, which some of you might know as a compassionate use, which allows the FDA to give green light to the use of an investigational medical product outside the context of clinical trials, not to collect information, so the book picture would not apply here, but again, to respond to a situation of need. You might have heard of ZMapp, which was, or is, a drug cocktail that was successfully administered to these two patients. Nearly 10 people took ZMapp, not all recovered from Ebola infection. FDA also plays a role in CBRN preparedness, so in responding to chemical, biological, radiological, and nuclear threats. It works in conjunction with other agencies and interagency partners to do this. Something that was quite timely in 2013, the mechanisms that allow the FDA to approve emergency use authorizations were streamlined, so that proved useful in the context of the Ebola and Zika crisis. And finally, the FDA, as is, memoranda of understanding with BARDA, DARPA, and other agencies. And crucially, these agencies, DARPA and BARDA, they funded and were actively involved in the development of vaccines and therapies for Ebola and Zika. So one more aspect. This ties into the medical countermeasures initiative. So medical countermeasures are FDA-regulated products that are used in response to a terrorist attack or a natural disaster, emerging disease. And FDA coordinates research on medical countermeasures, oversees deployment and use strategies of these drugs, and facilitates access to MCMs. So in the case of Ebola, for instance, there were a number of intramural projects, as well as a number of extramural projects. I'm just listing a few of the things that FDA was involved in between 2014 and 2016. Wearing yet another hat, you might have read about this. So FDA scientists at FDA actually came up with a new mouse model. Remember the time where we were not quite sure whether there was really a connection between Zika infection and Guillain-Barré syndrome. So there were a lack of models to study this connection, particularly in babies. So the FDA developed a neonatal mice that would be more susceptible to the development of the Zika virus and would start showing some neurological symptoms 12 days after the onset of the infection. Eventually, the symptoms went away. So FDA also dealing with that. Finally, in addition to all these hats that FDA wore during the emergencies, there's the vouchers that Robin alluded to. So the priority review voucher program was not created during the Ebola Zika crisis, but in December 2014, so this is a few months after the WHO declares Ebola an international emergency of public concern, all filoviruses were added, so including Ebola. And in April 2016, shortly after WHO issues the same type of declaration for Zika, the Zika virus was added. And as I'm sure many of you know, now with the 21st Century Cures Act, there's a voucher, one more for medical countermeasures. This is where, and basically this is my presentation. This is what I'm sure of. These are the hats that I have identified so far that I've seen FDA wearing during the Ebola and the Zika outbreaks. And this is where I don't understand the role of the agency very well. So when I look at the examples that I've just described to you, I see why FDA would be doing all of these things. When I look at the vouchers in particular, in the ways that FDA is trying to, or is forced in this particular case, because FDA is not exactly a fan of the voucher program, but the ways in which FDA is trying to incentivize innovation on certain types of diseases that have been neglected for a reason or another, this is where I don't see things coming together as well. Because if you look at the timeline here, by the time the viruses are added and are made eligible for the voucher, the outbreak has been raging for a while. It will be over before any of these drugs are approved. And the nature of outbreak is that they go away. Some of them will come back like Ebola. Others might not come back for decades. So even if the vouchers were to incentivize any form of innovation, which is, to begin with, a doubtful proposition, this reactive way of adding the viruses to the list, to me, strikes me as an inappropriate way of incentivizing innovation. So of all the hats that FDA wears, I'm trying to figure out this one based on the case studies on Ebola and Zika. And if anybody has any suggestions of things that I could add up here, or any thoughts about what to do up here with ad hoc incentives programs at the FDA, I don't see them working. I don't see them going away anytime soon. So any thoughts would be really, really appreciated. Thank you.
We've got lots of time for questions.
Good.
Yes, very interesting presentation. I think one non-FDA mechanism that's important that's implemented by Congress are statutory immunity from liability, and that was important consider Congress as an important lever here,
Okay.
not only in creating alternative mechanisms, but in pressuring the FDA. One thing that's a constant for the FDA is getting pressured by Congress and by patients groups and not responding swiftly enough. So I think the political dynamic is important when you consider the public pressures on FDA to allow quick responses to public health emergencies.
Okay, thank you. And so I was just reminded that in addition to creating programs like,
Could you try and summarize this?
that's what I was doing.
And his name too.
Nathan Cortez, SMU.
Nathan Cortez just reminding me that in addition to creating programs like the vouchers, Congress and other entities also apply pressure on the FDA, not only to respond to emergencies like this, but in ways that shape their policy long term. Robin.
Robin Feldman, there's another role the FDA is supposed to play but doesn't do very well, and that's competition authority. And
Right.
it comes up in a couple of contexts, and I don't know whether you'll find it in Zika or Ebola. One is in the citizen petition context, and I just finished a big study on this one. The FDA has the power to summarily deny things, to have to do other types of things when the citizen petition process is abused, which they've never done to date. Similarly, in the Orange Book context, they don't exercise any initiative when inappropriate things are listed there as well. My guess is you might be able to find something on Zika or Ebola in the Orange Book context.
Okay. Okay, thanks. So Robin Feldman noting that citizen petitions in Orange Book context also relevant for the type of research I'm conducting. Louis Grossman.
So I'm currently working on a National Academies Committee on the Strategic National Stockpile, which was originally established for medical countermeasures to terrorism and warfare, but its mission has expanded to, and it was very much involved in the Ebola situation. And I don't know exactly whether it's worth examining FDA in isolation from a system that is just an unbelievably complex intermixture of agency functions, and I've been surprised. I was brought on as the FDA expert, and I've been surprised how minimal my role has actually been in terms of FDA expertise. And so two things that do occur to me that they're involved in that you haven't mentioned that may not be relevant in the emergent vaccine thing, but one of them is waiver of expiration dates in these stockpiles, because this is because stockpiling is an essential part of this system. And the second thing is labeling and directions for the ultimate dispensers of this stuff, including, by the way, pediatric patients for whom there has been oftentimes no testing whatsoever, even if testing is commenced for adults and so forth. But I really urge you to bring in the other agencies.
Will do. So Louis Grossman, American, noting that other agencies have been heavily involved, perhaps even more than the FDA in the response to Ebola and Zika. Thank you very much for that. I might go back to you. There are a couple of things I did not mention, like blood supply, and the FDA did play a role in maintaining its integrity and all that, but thank you for reminding me of that. Rachel?
So I think this is so interesting. I want to follow up on Nathan's comment and just say that thinking about the FDA's sort of resistance to some of these as tasks foisted on the agency by Congress might be relevant. So when we, the last time we updated the priority review voucher list, it gave the FDA the authority to add diseases to that list by regulation, but they chose not to add Zika, right? Congress told them to do it because they hate the priority review voucher. It's really good reason. And so I think to the extent that we've gone too far in having Congress just give all of these additional responsibilities to FDA, it's got to be a big part of the story.
So that was Rachel Sachs from WashU, nuancing my point about the FDA disliking the voucher program and noting that the FDA actually has the ability to add diseases to the list and has chosen not to add Zika. That was through congressional action. All right, thank you very much.
Thanks to the organizers. It's great to be here. As you can see, the title's changed from the program. I hope that's okay because it's going to chase Anna's presentation so closely. My co-author, Richard Gold, sends his regrets he wasn't able to come. We're right in the middle of... he probably would have kept the original title. We're right in the middle of semi-structured interviews with some of the key players in this story, and so really appreciate your thoughts. Just going to sketch an argument based on sort of the interviews and document analysis we've been doing so far. So even in the context of biosecurity, research into emerging infectious diseases is beset by insecurity. IP without IP, or intellectual production without resort to intellectual property rights, can actually work. The goal of sort of this project is to connect those two claims and the underlying critical literatures through a case study of the development of an Ebola vaccine known as VSV-ZBOV. The novel claim that we're sort of working towards, welcome pushback on, is that if IP without IP is to work in the context of developing vaccines for emerging infectious diseases, we need to pay much more attention to this, the precarious nature of scientific labor. In late 2016, the promising results of a clinical trial involving that Ebola vaccine that some people call the Canadian Ebola vaccine, that it might offer 100% protection, possibly, against the otherwise deadly virus, were published in The Lancet. But the story of this Ebola vaccine, of course, starts much earlier, much before the 2013-2016 epidemic. And I'm going to start the story in July 2002 when a key patent was filed. On the patent, there were 3 inventors, Stephen Jones, Heinz Feldman, and Ute Stroer, all researchers based at the National Microbiology Laboratory in Winnipeg. The patent has been since granted in Canada, the US, and Europe, in not respectively 2010, 11, and 13. Europe was first in the string. Canada was last. Despite some media fanfare around this technology, right around the early stages of the research, 2004, 2005, commercial interest in the VSV-ZBOV did not quickly follow. The vaccine was first the subject of a non-commercial research use material transfer agreement with the U.S. Army Medical Research Institute in 2005. Then in 2007, a small company named Bioprotection Systems, based in Ames, Iowa, approached the Public Health Agency of Canada, which had then formed in the wake of SARS, or PHAC as I'll call it, about a potential license to that vaccine. BPS's business model, like many other small biotech/biodefense companies that were set up in the early aughts, was to chase various forms of new government fundings that follow the anthrax bioterrorism scare. But BPS's specific interest in VSV-ZBOV sprang from one of its employees, Raymond Flick, who's on your right in that image, who, after working with Heinz Feldman, one of the inventors of the VSV-ZBOV in Winnipeg, moved first to the University of Texas at Galveston, and then up to Iowa, and becoming later the chief scientific officer of Bioprotection Systems. Flick persuaded his superiors at the time, when he initially moved there, to approach PHAC about a potential license. Ebola had just been deemed a material threat to the United States in 2006. Negotiations began in the spring of 2007 for a potential license, not long after some pretty exciting research was published by Heinz Feldman and others about this experimental vaccine. Negotiations, though, were quite slow. It would be May 2010 before we had an actual agreement between the parties. In the process, BPS made a number of specific representations about its capacity to move this experimental vaccine into clinical trials, quote, as early as 2011. So this is from an access to information request that Richard and I pursued in 2014. Didn't get it for 2.5 years, but we've got a lot of the internal documents back and forth between the parties. When the agreement was finally concluded, you can't really see it, I got this actually from the Edgar database before we got it in our disclosure. The final terms of the deal had a number of terms relating to the commercialization of this vaccine. So BPS was required to use commercially reasonable efforts to commercialize the vaccine. Shelving or parking the technology was considered a fundamental breach. It was required to maintain records written records, of course, about its efforts to commercialize the technology, and submit quarterly reports, written reports, to PHAC about exactly those things. Despite those obligations around commercialization and commercialization reporting, by the time the Ebola epidemic began in late 2013, and for much of 2014, BPS, which was by then wholly owned by New Link Genetics, another company in Iowa, had failed to initiate a small phase 1 clinical trial. The media reported that BPS had shelved the vaccine. So in late 2014, we filed an access to information request, that's sort of the lingo in Canada, to figure out if that was really the case. We got back around 1,200 pages worth of documentation, and not a single one of those pages, and I should say, if anyone does this kind of research, we figured out a way to strip the redactions on many of the pages. Not the wholly blank pages, if anyone's really interested, but the ones that had partial redactions, we could see behind them. We haven't told PHAC that yet. Yeah, potentially. And so not a single one of those 1,200 or so pages actually tells PHAC anything about what BPS was doing to advance it. So as far as we can tell, based on the documentation, they weren't doing anything, despite that quarterly reporting obligation. Officials from PHAC, who I'm now interviewing, tell me otherwise. We haven't seen documents to prove this, but they say they were given regular but informal updates, face-to-face meetings, but no written records, which Richard and I are dubious of. So the vaccine was shelved, and I guess what we're starting to wonder is this is an agreement that on its face looks quite well written, but at the same time it wasn't enforced. Could a different kind of arrangement have sort of succeeded in moving this vaccine further along before the epidemic began? I think most of us might be more familiar with what happened after the epidemic began. We're interested in, again, what could have happened before to move this forward more quickly. And to engage that question, to be brief today, I want to return to Flick and Feldman, the two researchers I mentioned earlier. The two researchers published a number of papers together in 2003 through 2005, including two important papers about SARS. This is in the middle of the SARS outbreak. They're walking around in Hong Kong. The same research also translated into a number of patent applications. Feldman was on those patent applications as an inventor. Flick was absent. While patent law's standard of inventorship may explain that discrepancy, there's also empirical evidence to suggest that one's status in the lab, one's status in the field, can influence the allocation of inventorship. So I wanted to trace Feldman and Flick's respective exposure to patents and commercialization vis-a-vis their careers. Feldman is an inventor on a handful of patents. The SARS patents are the first in this string. When I spoke to him, however, the last thing he wanted to say he had any knowledge about was IP. I want nothing to do with it. That was someone else's work. Feldman, it seems, distanced himself from issues of IP and commercialization. Apart from disclosing the inventions to his employer, as he was required under Canada's Public Servants Inventions Act, he basically disengaged from IP issues. On the other hand, Flick's experience is quite different, right? So Flick was absent, but he does have some patents both before and after his time in Winnipeg, fewer in number than Feldman did. However, whereas Feldman sort of chose to move away, having the luxury of secure government funding, a secure government job, Flick had employment insecurity. So he moved first from Germany to Sweden, then to Winnipeg, down to Texas, and finally to Iowa. In 2013, he no longer had a job with bioprotection systems. His LinkedIn profile currently reads, "actively searching for new opportunities." So in my mind, it's possible to sort of reinterpret his exposure to IP and his career arc as markers of a sort of more moment of precarious employment, right? So he's got this he developed this critical, or uncritical rather, embrace of commercialization and intellectual property. He's quoted in this story in the Huffington Post in 2012, sort of echoing the government funding program's focus on bioterrorism as saying, quote, it's so easy to get your hands on a bioterror agent nowadays. And so I'm wondering if these two extremes that Feldman and Flick represent if there aren't sort of more creative, innovative approaches to vaccine knowledge production that might be possible. If it's hard for Feldman, on the one hand, who wants to disengage, and Flick, who has to embrace intellectual property and commercialization-related norms to develop new approaches to vaccine knowledge production. Because historical example exists of researchers themselves doing this, and of course contemporary ones as well. So in a forthcoming case study, which I would really recommend to folks here if you're interested in the IP without IP literature, Amy Kepczynski documents sort of what's been going on with the global influenza surveillance network. And her point in that case study, which involves a number of interviews as well, is that this wasn't IP without IP and also without law. It availed of another legal mechanism, which is contract law. And she talks about how, in a context of really high cost, highly uncertain vaccine knowledge production, resort to contract law has helped a sort of globally distributed group of researchers to work together with sort of clear norms of credit sharing and information sharing to the benefit of vaccine knowledge production. What we're trying to sort of raise as a question through this case study of the Ebola vaccine is whether the sort of employment insecurity that many researchers now face is sort of a necessary background condition that has to be addressed in order for researchers to develop sort of novel solutions to producing knowledge around emerging and infectious diseases. So I'll stop there and just thank Richard and an anthropologist that I've been working with on the qualitative dimensions of this project, Janice Graham. Thank you.
You can select your questions.
Sure. Bob Cook, Deegan?
So in answer to your question, is there an intermediate space? Yeah, there is. And there are a bunch of people in the vaccine space who learn usually from mistakes. And one guy that you might interview is Bob Johnston at Global Vaccines. He lost access to his own IP and learned from that he needed to build that into his licensing. So he started, that's what Global Vaccines is intended to do. And I think he could probably link you to a whole bunch of people who are pretty sophisticated about thinking one step ahead of the IP game.
Before I repeat the question, can you tell me at what career stage he was when
he was a relatively senior investigator when he started the new company. He was a kind of an intermediate stage faculty member who licensed, UNC screwed up the licensing. That's how he learned. And that licensing that was screwed up is when he was kind of an intermediate level faculty member.
Yeah, thanks. So Bob Cook Deegan from Arizona State is sort of pointing out that there's lots of room in between the two sort of caricatures I offered up to do more interesting and potentially responsible things. My word, not yours. Completely agree with that suggestion. I didn't go into the details for reasons of time, but this agreement in this case actually had, research use, educational sort of carve-outs for the institution, and so the agreement actually looks quite good if you're going to think that licensing out is the only way to ensure development. It wasn't enforced, and that's an institutional problem that we're concerned about. What we're really trying to do is look backwards as well and think about other approaches altogether, perhaps one that doesn't even try to secure IP in this case. And we're really just sort of at the brainstorming phase around those questions, but I appreciate the example, and it would be good to talk to people who aren't immediately involved in this case about the sort of troubleshoots they've developed. So thank you. Jake?
Yeah, thanks. So, first of all, I find this to be just incredibly compelling and frightening. When is the screenplay coming out? That's kind of what I want to know. But on a more serious context, to the extent that it is true that job insecurity is going to be a background condition for the intellectual development of important drugs, vaccines, and for that matter, things that could be related to kind of bioterror agents, is it possible that one solution is actually more intellectual property? That the idea that by kind of making sure that researchers take part in some of the licensing royalties that come with patents, that would alleviate some of these job securities here to prevent some of the kind of bad activity that you were mentioning earlier. It's one thing to have job insecurity as an untenured faculty member. It's another thing to have job insecurity as an untenured faculty member when you know that whether you keep this job or not, you're going to be due whatever royalty streams are coming through based on your invention.
Great. So Jake Shurko from New York.
Law School,
Law School, thank you, sort of suggested or asked me to think through the possibility that it may not be a matter of no IP or less IP, but more IP, because of that might actually help folks who have insecure employment situations. Really like the suggestion, and nestling up to the IP without IP literature, I think is sort of not necessarily what I'm trying to do. It's just the closest area for really more broadly what I mean is people experimenting with IP and moving away from standard sort of approaches. And you know, I want to think about the employment law piece. So I know there's some literature out there about like pre-assignments of IP by postdocs, and is that increasing, and does that hurt their ability to move with this technology? Raymond Flick was in Winnipeg when they did this work on Ebola, and they had to go, you know, like what if he could just travel with that? As a concrete thing, non-compete clauses and so on. So I think the employment law aspects are sort of under-theorized in the issue of how do we sort of give researchers more ability to tinker with existing tools, and more IP might be part of that. So thanks.
Sure.
I'm going to stop.
So 3 logistical caveats. The first is that I lost my glasses yesterday, so when you ask questions, can you say who you are even if you know that I know you? Unless you're Nicholson, because I can recognize you by your pants. The second is that this is me being a little foxy with the FDA. So I'm not an FDA person by any means, as you'll soon find out. And so, you know, there'll be mistakes. And so, you know, and I'm really here to get your help. And I've got some help before from some expert people in the field already. The third is the sort of boilerplate caveat. This semester I'm actually over at HHS as a special advisor, and that's why I've been running in and out all morning, because there's an ANPRM going out allegedly next week, and so anything I say is just in my personal capacity. Okay, so the question that I'm seeking to deal with in this paper is really trying to grapple with a way of thinking about the kinds of problems the FDA gets to regulate. When people have talked about the way the FDA regulates problems, they generally talk about the kinds of products they can regulate. So is it a drug? Is it a device? Is it a food? Is it a cosmetic? But rarely do I see a systematic survey and classification of the kinds of problems the FDA seeks to regulate. What do I mean by that? Well, in general, we take it for granted that the FDA can regulate problems with 3 characteristics. The first characteristic is that in the context of drugs, I should say. The first characteristic is that the side effect that the FDA seeks to prohibit or prevent is a direct side effect. Number 2, on the recipient, the person who takes the drug. Number 3, of a physiological nature. So it tends to be a direct physiological side effect on the recipient. In this paper, I argued that there are certain side effects that the FDA should take into account that are indirect, that occur to third parties, and that are sometimes non-physiological in nature. I'll first define and provide examples of all of these side effects, and then explain why and how FDA regulation should proceed along these lines. Now, I'm calling these side effects, really another word can be ancillary effects, incidental effects, etc. But partially for catchy titles, I'm using this term. The other thing I should say is I'm only talking about drugs here for various reasons that I'm happy to talk about in the Q&A, but really it serves as an example. So this is my only slide that will have some not so fancy animation. So the first kind of effect I'm thinking about are indirect effects. In the paper, I think about different ways of thinking about indirect effects, and I settle on a definition borrowed from the indirect effects from the proximate cause test in tort law, which tends to have 3 characteristics. First, there has to be an intervening cause, which is independent of the original act, be a voluntary human act or abnormal natural event, and occur in time between the original act and the effect. And this can occur in various ways. So you can have drugs like Viagra that seek to promote certain kinds of activities, and those activities then have follow-on effects. And then you can have risk compensation issues. So if you take PrEP, some people claim that there are risk compensation issues similarly with Plan B. And the risk compensation can result in some people claiming an increase in the danger that was meant to be averted. So if there is great risk compensation and condom migration with PrEP, but people don't adhere as well as they're supposed to, et cetera, one could see a world in which HIV rates will increase, though I don't think that there's any evidence for that. Or you can also see other harms come up, so the spread of other STDs and other diseases. In the paper, I consider bioethical objections to considering indirect effects in agency contexts, and I reject them. I'm happy to talk about that in the Q&A. The second kind of effect I think of are third-party effects. For an effect to be a third-party effect, there has to be a recipient of the drug and someone else around the recipient of the drug who is incidentally exposed to an effect of the drug. These third-party effects could be direct. So, if the third party is exposed to testosterone gels and patches, which actually I'm indebted to Lewis for helping me think of, or even secondhand smoke, though of course cigarettes aren't really a drug, but I'm just throwing that in there as an example, or indirect. And so by sofosbuvir, which I can never pronounce, the kind of indirect I'm thinking of is, you have this drug that's approved by the FDA, and Medicaid patients then sue the state saying we want coverage for this, and that could ultimately limit the coverage for other patients within the Medicaid system. The paper distinguishes between various ways of thinking of third-party effects by relying on concepts from bioethics that some people term micro-level ethics, meso-level ethics, and macro-level ethics. Micro-level ethics involve the ethics of individual interaction, so how a researcher deals with a specific patient. Meso-level ethics has to do with the ethics involving your family, your community, your workplace, and macro-level ethics, the ethics of interaction, let's say among your state, the government, and even globally. So antibiotic resistance, for example, would involve macro-level ethics because you're talking about a global condition. And I argue in the paper, after some agonizing, right, that the FDA has a duty to protect individuals at all of these levels, so third parties in all of these contexts. And finally, there are non-health effects. And by non-health effects, I sort of first step back and think about what it is to think about health effects versus non-health effects. And I argue that there are spheres of activity in which people act. And Glenn pointed me to Dan Brock, who is this bioethicist that talks a little bit about this. But I also look at the Palm Wonderful case, where the Supreme Court really exemplifies this kind of reasoning. What the Supreme Court says in that case is, and there are people here who know this case better, is when we're going to consider, so I think everyone knows the Palm Wonderful case, right? So this is the case in which the Supreme Court says that the FDCA doesn't preclude Lanham Act claims. And the court says, well, let's look at the purposes of each statute. And the purpose of the FDCA is not to protect against the kinds of harms that the Lanham Act is supposed to protect against, right? So they're complementary, and these are different sets of harms. So my claim is that that you can look at the purposes of a statute and of a sphere of human activity, and that can tell you what kinds of purposes would count as health effects or not. But the fact is that these claims as to purposes are quite malleable. So you can so the term financial toxicity, for example, seeks to break down the boundary between the notion of cost and quality, as Zach Buck has argued in a recent paper. So the idea is that distinguishing what a health effect is from a non-health effect is inherently discursive and subject to change. And of course, something that is allegedly not a health effect, so let's say a particular drug is going to cause racial inequities, perhaps. Racial inequities ultimately may result in health-related issues. The drugs that I suggest we see conversations regarding non-health effects arising in, again, Plan B comes up. So the GAO report that came out investigating FDA's non-approval of the OTC application said that the FDA was worried about teenage sex, lack of parental control, which all have to do really with non-health effects. RU 486, non-health effects again, we're worried about abortion, though I sort of say, well, maybe it's also, some would claim it's a third-party effect because, it's abortion, right? And then on the progressive side, there were many people who argued against the approval of Bidal, saying that this would reify racial categories. Another argument, or researchers have found that in the case of Viagra, some women claim that they feel disempowered with respect to their partners for various reasons, and that's something that the research is not conclusive on, but that's another kind of non-health effect that then one can think about. There are exceptions where the FDA takes into account effects that look like these, but that tends to be cases where Congress tells them you must. Right, so secondhand smoke is one example, though again, not counting cigarette as a drug, but Congress explicitly said, look, you've got to think about secondhand smoke, and that was the first time that the FDA used the term secondhand smoke in the Federal Register. Before that, it was always the CDC. Antibiotic resistance, though, is the one example where the FDA said, we have public health powers to think about these third-party global indirect effects, and that is the one area where the FDA acted by interpreting the term public health fairly broadly. I present three arguments to support my claim that the FDA should be able to take into account these additional effects. The first is just the logic of administrative decision-making. Scholars from Cass Sunstein, Ricky Revesz, and others have argued that the only way to make a decision in the administrative context is to do a cost-benefit analysis that takes into account ancillary effects. Ricky Revesz actually calls this side effects in one of his articles. But these side effects in all these cases include indirect third-party and non-field specific effects. So one example of this are health effects that some of you may know from the environmental law context. Justice Breyer refers to this in his concurring opinion in Whitman versus American Trucking, where he says, look, on one hand, you're worried about a particular health regulation. But on the other hand, this regulation can cause a decrease in income and wealth, and that in turn can cause reduced health because health is connected to income. So we see this sort of indirect third-party, non-field specific reasoning. So that I argue is inherent to the nature of cost-benefit analysis in the administrative context and should apply in the FDA context as well. The second reason is democratic accountability and transparency. The fact is that so there is a debate as to whether the FDA should be taking into account morality considerations at all. And in the paper I say, well, I think there are strong arguments for the FDA to take these into account. I mean, ultimately, when there's a change in administration, ultimately for your vote to count, right? Essentially, the administrative apparatus should reflect the values of a given administration to some degree. And I can talk about that more in the Q&A because I know that may raise some questions. But whether or not this is desirable, the FDA does do this, and I think it is important for the purposes of transparency for these considerations to be explicitly acknowledged and engaged with in the process so that they can be rebutted if necessary. And third, I believe that it's only by explicitly taking into account some of these considerations that the FDA can get full information about some of these issues. So, for example, had the FDA spoken explicitly about its teenage sex concerns on the OTC issue for Plan B, we could have publicly adduced evidence saying, well, actually, there is no evidence of this, and to the contrary. I address objections in the paper that I won't go into related to time and cost, expertise, and federalism, but I can talk about those in the Q&A. And finally, I argue that the statute is calibrated in a way that actually allows the FDA to do a lot of this. So that in the 10 seconds and I'll be done. So essentially, that the statute allows the FDA, when it's talking about more extreme measures, it says that the FDA should, it'll take me longer to finish if you hold that up, sorry.
You're 23 and climbing.
So ultimately, that the FDA has more leeway when its activity, when its action is less drastic. So when someone's talking about advertising, it's able to take into account, quote, the good and well-being of individuals. But when you're talking about the withdrawal of a drug or the failure to approve a drug, then it's more narrow in what it can consider and has to consider only public health and safety, but that too allows for sufficient leeway. So thank you, and I'll stop there.
You got 4 minutes for questions. You can
Yeah.
use them.
Patti.
Patti Zettler.
Yeah.
So I have two thoughts. One, I would push back a little bit on the claim that antibiotic resistance is the only drug context in which FDA has taken into account indirect, third-party, et cetera, effects. Ebola is an example where there was a REMS required at the time of approval that took into account the fear that PrEP would change people's behavior. The TERP drugs, the opioids, the transmucosal intermediate release formulations that are like lozenges and tabs you put on your tongue. There's a REMS to address exposure to third parties, including children, and so on. But so just something to consider. But the question I have for you is that a character for me that suggests that something is not within FDA's expertise? But is FDA the right decision maker? So maybe we want the government involved in questions like, does the approval of Bio reify racist biology in a way that we don't want as a culture? But is FDA the right body to make that decision, or should that decision be made apart from the decision about safety and effectiveness?
Absolutely. So Patti Zettler pointed out that there are REMS requirements to consider some of these issues, and I think that's really helpful. And I need to I wonder. I want to talk to you a little bit more about the 2007 Act, just because I'm curious as to whether any of these considerations were behind that. So I'd be curious. So we should talk offline later. And then on. Oh my God. So Dove Fox from San Diego asked if an example that Sonia Suter raised in her presentation would be something that I should consider. And I'll have to think about that more, but I think it is something that I could fit in. Do I have time just to take a question without answering it? No?
I'm afraid not.
Okay. But I'll talk to you offline. Thank you.
Okay. Well, thank you all for having me. So today I'm going to talk about a work in progress entitled Closing the Regulatory Gap for Synthetic Nicotine, which is about FDA. This is a collaborative project, and at the early stages with Micah Berman from Ohio State's Colleges of Public Health and Law, and Natalie Hemmerich, a postdoctoral fellow at Ohio State's Center of Excellence in Regulatory Tobacco Science, which is funded by NIH and FDA, to point back to Rachel's talk from yesterday. Before I get started, I wanted to mention that Erica Lietzen at Missouri has created a listserv for those of us that teach food and drug law or work in this space, and she has made me co-administrator. So if you would like to join the listserv, email me and I can send you instructions about how to do that. As I said, today I'm going to talk about synthetic nicotine, and as the FDA-focused folks in the room will know, under the authority of the Tobacco Control Act of 2009, FDA now regulates everything that meets the definition of a tobacco product under the law, including e-cigarettes and vaping products. But some companies have begun to sell synthetic nicotine vaping products that they claim are not tobacco products under the law. So this leaves a gap in the regulation of nicotine products that may pose risks for the public health by allowing addictive products with uncertain risks and benefits on the market without FDA oversight. So although I think, as many folks think, vaping may be less harmful than smoking cigarettes, nicotine itself has potential adverse health effects, including effects on developing brains, including in adolescence, such as negative effects on working memory, a higher risk of smoking in adulthood, and greater vulnerability for addiction to other drugs. So we argue that industry is right. Synthetic nicotine is not a tobacco product, so is not subject to FDA's requirements for tobacco products. But that's not the end of the inquiry into FDA's jurisdiction. So instead, we make the argument that synthetic nicotine is a drug under the statute, and that there may be good policy reasons for FDA to regulate it as a drug. So to make this case, I'm going to very briefly tell you what synthetic nicotine products are and why they're not tobacco products, talk a little bit about why we think they're drugs, and then talk about some of the policy reasons it might make sense for FDA to regulate them that way at the end. So synthetic nicotine is essentially a vaping liquid. There are many different mechanisms one can use to vape. And this is an example of a synthetic nicotine vaping liquid. It's Zettler, eJuice Direct, describes it as freshly picked diced strawberries blended with a rich and creamy vanilla ice cream for a sweet and fruity milkshake. Full disclosure, I've never vaped, but some of my students who are vaping enthusiasts assure me that it tastes as good as it sounds. It comes in 3 different nicotine strengths, and its seller also says this is tobacco-free nicotine not derived from tobacco leaf, stem, or waste dust. And that is the key to why synthetic nicotine is not a tobacco product. So this is the statutory definition of a tobacco product. As you can see, it means something made or derived from tobacco. And synthetic nicotine created in a lab without tobacco does not meet this definition. So in May of last year, FDA promulgated a regulation deeming everything that meets this statutory definition to be subject to the requirements for tobacco products that include things like pre-market authorization for new tobacco products and other and advertising and promotion restrictions. So if synthetic nicotine escapes those requirements because it's not a tobacco product, these products may come to dominate the vaping market as the sort of only products that are not subject to these arguably restrictive FDA requirements. But just because synthetic nicotine is not a tobacco product does not mean it is not subject to FDA's oversight. So this is the definition of a drug. As you can see, the definition of a drug turns on the product's intended use. So intended use refers to the objective intent of the entity responsible for the product's labeling, which usually means the manufacturer or seller. A drug is something intended to treat, prevent, diagnose disease, or affect the structure or function of the body. And it's because of this last piece of the definition about affecting the structure or function of the body that the definition is actually quite broad. So it includes things we think of intuitively as drugs, like cancer therapies, as well as things like antiperspirant that affects the sweat function of the body, but we may not automatically think of as a drug. Although the definition is quite broad in the statute, the Supreme Court and the D.C. Circuit have limited FDA's discretion to apply this definition to tobacco products in a couple of cases, Brown and Williamson and Sotera. And in short, the courts have said, FDA, you can't call a tobacco product that is customarily marketed a drug. But importantly, we argue this limitation does not apply to synthetic nicotine precisely because, as I just said, it's not a tobacco product. So the inquiry into whether synthetic nicotine is a drug should be the same as for any other product, which is simply a question of intended use. So we think there are sort of three buckets of evidence that suggest that synthetic nicotine is a drug. First, the company's representations about synthetic nicotine, which is probably the least controversial claim to make. Historically, FDA, industry, and the courts have all agreed that what companies say about their products can be evidence of intended use, at least when we're talking about unapproved products. So synthetic nicotine companies routinely make both disease and structure function claims. These include things like smoking cessation claims, which are disease claims because of the causal link between smoking and all kinds of diseases. But more common and perhaps more difficult to remove from promotional materials are structure function claims. So some companies say things about the, quote, biological impact of their products, which are sort of explicit claims that their products do something to the body. But even just listing nicotine as an ingredient might be a structure function claim. Because nicotine is so well known to be addictive and to have other physiologic effects. And indeed, many of these companies also have warnings and disclaimers about the addictive and physiologic effects of nicotine. So claims would be one category of evidence. The second kind of evidence of intended use we point to is product design. So specifically the inclusion of nicotine in the vaping liquid and in different strengths. So as I just mentioned, the biologic effects of nicotine are quite well known. And with synthetic nicotine, manufacturers clearly must design their products to contain nicotine, unlike arguably tobacco products in which nicotine is naturally present. And additionally, these products have different strengths of nicotine, while at the same time companies say one reason to use synthetic nicotine is because unlike tobacco-derived nicotine, it's tasteless and odorless. So why have different strengths if not to affect the body in different ways? The third category of evidence we point to is likely the most controversial, and that is consumer intent. So to remember that intended use means the company's intent, not what the consumer intends to do with the product. But in rare cases, consumer intent might be probative of what companies intend. So to my knowledge, and if others know of other cases I'd be interested to know, there's only one case in which a court has said consumer intent alone can be evidence of intended use, and that was a case in which the government did an undercover buy of nitrous oxide in an unlabeled balloon at a rock concert. The court basically said, if you're at a rock concert and you're buying nitrous oxide in a balloon, everybody knows what's going on. You don't need labeling to figure that out. But synthetic nicotine likewise may present an unusually compelling case for the relevance of consumer intent. So for example, recent research suggests that the vast majority of smokers who use vaping products do so for smoking cessation benefits. This may be a similar situation where consumers are predominantly using or even exclusively using vaping products for their effect on the body. But this is probably the least compelling or the most controversial legal argument. So just because FDA can regulate something does not mean that it will or that it should. And indeed, FDA often uses or sometimes uses its enforcement discretion to not regulate certain novel technologies or not enforce certain requirements for novel technologies. So in other words, if you buy our argument that synthetic nicotine is a drug, the next question is, well, should FDA be involved? Should FDA regulate it as a drug? And to be clear, we're really only in the preliminary phases of thinking through how to answer this question. but I want to propose a few reasons why it might make sense for FDA to regulate synthetic nicotine as a drug. So one is the sort of classic conception of what FDA is, which is consumer protection. Even if vaping products are less harmful than cigarettes, these are addictive products with neurological effects, and so maybe we want FDA involved to protect consumers, and so on. A second benefit is one that many folks in the room have written about and will be familiar with, but FDA's gatekeeping role for medical products can encourage the creation of knowledge and beneficial innovation. So that FDA serves a gatekeeping function, and that companies have to sort of prove what their products actually do to FDA, incentivizes research into the products, and gives us more knowledge about the products, and may encourage a market of products that actually work, like drugs, compared to dietary supplements, where FDA has no gatekeeping role. So if we leave intact a significant regulatory loophole for synthetic nicotine, we may lose out on an opportunity to learn and understand what vaping products do, and in what contexts we can create a market of truly beneficial, or at least safer, nicotine consumption products. So a third benefit is that classifying synthetic nicotine as drugs may enable FDA to treat them similarly to tobacco-derived vaping products. So there doesn't really seem to be a rationale to treat the two buckets of categories differently, at least from a public health perspective. And as I mentioned last year, as of last year, vaping products that are derived from tobacco are subject to things like pre-market authorization. So if synthetic nicotine is called a drug, FDA may be able to do may have similar sort of oversight of those products. So the biggest worry about FDA involvement may be burden on the industry. But there may be ways for FDA to use its enforcement discretion or flexibility to ease some of those burdens. We have not thought through all of the options there. If folks have ideas, I'd be very interested to hear about it. But I learned last night from Lewis that Congress is considering tinkering with how over-the-counter drugs get to market. So there may be some ways to create faster pathways to market for synthetic nicotine as an over-the-counter drug without having to go through sort of an individualized approval process for each and every product. So I'll stop there, and to summarize and paraphrase noted legal scholar Brittany Spears, synthetic nicotine is not a tobacco product, not yet a drug, but there may be good reasons to regulate it like one. Yes, Lewis.
So actually, in the context of tobacco regulations, as I'm sure you know, FDA recently revised its definition regarding intended use, and then when the Trump administration came in, I think they pulled it. I forget exactly what the status is now, but the definition of intended use, which talks about circumstances and so forth, just wondered if you could reflect on the implications of the outcome of that for your argument.
Sure. So Louis Grossman asked about a recent, FDA recently attempted to revise its regulatory definition of intended use and has pulled back on that definition. So FDA finalized that regulation in January, and then Pharma and Bio, I think, and I know Sidley Austin was one of the firms involved, submitted a petition asking FDA to take back sort of the implication that consumer intent could be evidence of intended use. FDA has stated the effective date of the regulation, but hasn't actually pulled the regulation. But that is part of why I say that suggesting consumer intent can be evidence of intended use is most controversial. I think it'll be, I think that will certainly, what happens with that will certainly inform how we write the paper, but I don't think it changes the ultimate analysis based on the product design and the claims about the products. Hank, and then Alta.
Two quick questions. Are nicotine patches regulated as drugs? second, if they sold this as something to be eaten or drunk, could it be a dietary supplement?
So Hank Greeley asked, are nicotine patches regulated as drugs? And if synthetic nicotine were sold as a product intended to be ingested, could it be a dietary supplement? Yes, nicotine patches are regulated as drugs. And I would say no, it cannot be synthetic nicotine could not be a dietary supplement. FDA has previously said nicotine is not a dietary ingredient, and dietary supplements must have a dietary ingredient. So maybe there'd be,
Found in foods.
even though it's found in foods. Yes. Alta.
The word synthetic is what's catching my eye, and I just don't remember enough about the definitions in the area of biologics and food, actually, to know whether or not this phenomenon that you're identifying is actually bigger than just tobacco. That is, when we synthesize fake meat out of pure plant material, or when we synthesize a biosimilar or biologic, that is, without having started with a cell, which we're getting very close to doing, are they also going to fall into this little regulatory void because of the way the definitions currently exist? I just don't remember the language. You may be onto something that's a lot bigger than just, vaping.
Yeah, so Alta Charo asked whether synthesizing other kinds of products like food, like lab-created meat, has a similar effect on definitions under the Federal Food, Drug, and Cosmetic Act. That's a really great question. I haven't thought about it. I suspect for food it wouldn't, because the definition is so circular that food is something used as food, and yeah, right, plus chewing gum, and laboratory developed meat, is I guess used as food, but certainly something to think more about.
Yeah, for dietary supplements has the reverse effect, that a synthetic version of a natural substance is not a dietary ingredient.
Right. Okay. Greg.
This is maybe more of a matter of regulatory policy than legal interpretation. But what are your thoughts about how to go about drawing the line at the south end? And people occasionally bring up caffeine as an example. One could even bring up chocolate or sugar. Imagine caffeine that doesn't come from the bean, but comes from the lab. How do you think about that problem, assuming you don't want the FDA to regulate caffeine or chocolate bars?
So I'm sorry, I can't read your last name. I need better context. Greg Block asked whether where to draw the line at the bottom, whether caffeine and things like that should also be regulated as drugs. So there's an easy answer, which is I think that Congress has answered this question, because the definition of a drug actually says things intended to affect the structure or function of the body, parens, except food. So caffeine that's in food is sort of by law not regulated as a drug. And there are times when FDA has regulated caffeine as a drug in powders. As a regulatory matter, I think it's a much more difficult question to know where to draw the southern line.
Is not delivered in coffee. Then at times in the past it has been regulated?
Like caffeine powders, yes, that have been marketed as not as foods, not as, yes. But anyway, I have to stop. Yeah, sorry.